Your Honor, I have one, and just one. It's a technical question, and I'm not arguing with the court.
You wouldn't do that.
Not that I'm just not. But a technical request. I'm hearing what the court has ordered is that the general financial, I think you said the general financial statement of the defendant can be gone into, or status.
No, a statement of general finances.
That's the court's ruling on that issue.
Yes.
I'm not sure that we had that on the record. That's why. I think we may have discussed that. It may have been on the record, but I just want to make sure on the record we have whatever the court's ruling is.
I think that was the ruling, and I reiterated it just before the break. Were you writing down what I was saying?
Yes, sir.
It was on the record.
Okay, that's fine. Thank you.
Might I be heard on one matter, as well, before? Let me offer one alternative solution to another problem.
All right.
With regard to the issues of the grand jurors being individually interviewed by all of us, both sides, I assume there's 19 grand jurors, but there was a court reporter who was present as well, and presumably she's a witness to that as well. We would accept the defense's suggestion to the alternative resolution, based on your call entirely. This would be your choice entirely. But we would offer as an alternative, if the court's willing to do so, and we'll accept it, that one of the 3 prosecutors present would be made available as a witness in this case in lieu of the grand jury. This is done for purposes of protecting their identity, as we had represented to them we would during the course of those grand jury presentations, and the concern that the court has about keeping this matter moving. We're talking about 20 potential witnesses. So we would offer that as an alternative, if that's acceptable to the defense, and if that's acceptable to the court. And the court would make the determination as to whether you prefer to do it that way or prefer to proceed by way of interview of each of the 19 grand jurors, and the court reporter as well.
May I have just a second? Off-the-record discussion held at counsel table. Okay, I understand that the district attorney is saying they would pick one of the people. I don't know that all 3 of them were in the room at all times, but they would pick one of the 3 of them to testify. We've already heard what they're going to testify to. I think that under the circumstances, particularly in light of the fact that there's that one grand juror that's asking questions about fingerprints, I just have a feeling it would be appropriate for us to interview the rest of the grand jurors and find out what everybody says happened. And we can still decide, when it's all done. We may end up with a stipulation with the prosecution once we've had a chance to investigate. But I think it's gone. The ball's rolled too far in that regard. If the record is, and I'm not arguing with the court on that. The record is the record. But if we can go behind it, then we should be allowed to talk to the other people in the room.
Well, I would consider. This is a difficult problem. It's not an easy problem. And the grand jury, when they come to serve, expect their identities to be protected and not to be exposed to cross-examination. That's not something that's anticipated. If the prosecution is withdrawing their request to call the grand jury foreperson and intends to try to prove the way that the records were not touched by the child during the proceedings, then the court would accept that withdrawal of the request to call the grand jury foreperson. I don't see any particular problem. Who would be the district attorney testifying?
Your Honor, it would probably be Mr. Auchincloss. There were 3 of us present at the time that the boys testified initially. They were recalled at the end of the proceeding. Mr. Sneddon at the time was involved in a separate trial in Santa Barbara. He was trying the harms case at the time. He was not present during the second time. But it would be Mr. Auchincloss who would be testifying. He certainly witnessed all the events.
And so we'll have Mr. Auchincloss's statement and his criminal history records and all that so we can evaluate him as a witness. I'm saying that to be funny. I'm sure he doesn't have a criminal history. But we do want to have a statement of the witness, if they call him as a witness.
Is that a soundbite?
It was a kind soundbite. But as far as the statement is concerned, the witnesses, we are supposed to have the information about the witness and their statement, and
That's true.
That's part of discovery. So I'm asking for proper witness discovery, which, would include all those things.
That's fine. That's what he's asking for. But I just want to make clear that I'm not bargaining with you. If he wants to call the other 2 district attorneys that were present, I'm not bargaining with you. You know, you are offering one for one. That wasn't what I was suggesting. I was saying if you want to withdraw the calling of the grand jury foreperson and submit yourself, or that you may, and if he wanted to, you know, talk to the other district attorney that was present, you know, it's the same problem, isn't it? But I do think that the correct, you know, I do appreciate and think the right choice is to not call the foreperson and involve the grand jury in this hearing. So I appreciate that. So that being the case, I'll vacate the order that I was either going to make or did make about interviewing all the grand jurors, and that won't come into effect unless we get back to calling a grand juror. All right.
Could I ask, just, since the district attorney actually raised it, the court reporter is under certain statutory obligations of confidentiality as are the grand jurors. Could the court reporter be relieved from those obligations, to the extent that we could inquire of her of the circumstances in which she recalls the evidence was handled? I mean, we know who she was. Her name is on the, I won't repeat it, but her name is on the transcripts.
Yeah.
And I don't see why that would be a problem.
Let me consider that.
Okay.
I'll need to look at what restrictions they have. You don't think they actually watch what's going on, do you?
There's a possibility.
Okay, let me look at that. Do you know what code sections? I'll have to find them. What protections they have.
I did cite code sections. I just closed it. But I did cite the code section, the general area that talks about grand jury. It's 9-something. Let me just see if I can find it here real quickly. 924.1 is the grand jurors, and it's right around that same area.
It talks about the court reporter.
Yeah, somewhere in that same series of code sections.
Okay, thank you. I'll look at that this weekend and tell you Monday, and...
Okay, would the court like me to get the exact code section and send it, or...
I think we can find it.
I'm sure.
If it's in this area, don't worry.
Yes, thank you.
If you find it some other area, some other code or something, I'd appreciate if you just...
Yes, sir.
Phone carry or something. Nothing formal.
Yes, sir, I will.
Let the other side know. Then we have, the next item is the defendant's motion readmissibility of evidence related to George Lopez.
Again, we briefed it. I guess the main point that I want to make orally here before the court is that in a criminal case, the defendant has the constitutional right to confront and cross-examine. And generally, if you have a good faith belief that something is true, you're entitled to ask questions on cross-examination to test the recollection and test the credibility of a witness. And I think that the court's pre-trial rulings on this were based on information the court had at the time. But I think it's very clear at this point that we have a good faith belief that Gavin Arvizo was involved in this wallet incident with George Lopez. And the prosecution has already raised, in their own testimony on direct, they raised the issue that there was a falling out with George Lopez. I think that just stepping back from the fact that this is the Michael Jackson case and that it's George Lopez, who is an actor, ordinarily, fine, we'd be able to say, we'll just find out what it was about and get to the bottom of it. And we understand the court's ruling. We've all tried to abide by it. But it seems to me that at this point there's more than enough evidence to suggest that we should be allowed to vigorously cross-examine and find out. As you know, from what we have from the various interviews, there is clearly some incident that involved David Arvizo and George Lopez that apparently involved the wallet and the accusation that the $300 was taken out of Gavin's wallet. So it's Gavin's wallet that Gavin claimed he left there and claimed he had $300 in it, which is, David claimed he had $300 in it, which is inherently strange to start with. Secondly, we have information from Louise Palanker that it was Gavin who was brought into it reluctantly by his father to say how much money was in the wallet, and he didn't say, no, there was no money in the wallet. He said, oh, I can't remember, based on her version of things. That is enough of a good faith belief that there's something going on here with Gavin specifically that is part of the same pattern that occurs throughout, and we've shown that there's parallel patterns. Once there's a falling out, there's an accusation, and the accusations often escalate. What we have at the moment, as defense lawyers, we have to defend. What we have at the moment is we have the prosecution putting the witness on the stand and saying, well, was there a falling out with George Lopez? Yes, there was, and we can't go into it. So I think we have a good faith basis, and they've brought the subject up. Even if they didn't, I think we could go into it, but they certainly brought the subject up. We should be allowed to freely cross-examine and really test the recollection and the credibility of the witnesses in what is a particularly critical area and an area that even the prosecution felt was warranted to bring up to this jury.
Judge, if I could go back and put this in perspective as to the way I recall this issue coming up. I recall being part of a discussion with the court and counsel and the attorney for Mr. Lopez, and I recall that the motion was to quash the subpoena. And as I recall it, the decision that was made ultimately, at the completion of the day, was that the court indicated that you would not release Mr. Lopez from the subpoena, but that you asked the lawyers specifically to file information to you with regard to the incident involving the wallet, so you would be in a better position to evaluate whether Mr. Lopez would be a witness or whether it would qualify for some motion under 403. To my knowledge only. I can only speak for myself. I've never seen anything filed by the lawyer in response to the court's request as to what I understood was going to be the next step. And let me tell you, from our perspective, how we feel about it. Our recollection, and from a review of the transcript of the defense's opening statement, Mr. Mesereau said that it was Janet Arvizo, not David Arvizo, who was involved in this wallet incident. And the purpose for us asking questions of people who knew about the incident was to show that it was, in fact, David Arvizo and not Janet Arvizo, because the defense had made a representation to this jury that it was Janet Arvizo who was involved in that incident, and she was not, to the best of our knowledge. So with regard to the good faith belief, now the defense says it was David, but that wasn't what they said. I believe the transcript will bear out, in the opening statement. And it was for that reason that we asked the questions of the witness that was on the stand. Putting aside the change in position by the defense, we believe further that the information is that the father, David, tried to induce the child to claim that there was $300 in a wallet, and the child refused to do so and was reluctant to do so. So, I guess our position is, we would like the court's order that Mr. Lopez be a witness in this case to stay in effect pending the fact that the lawyer file some kind of declaration or pro-offer proof to the court, and then at that point either side could make whatever motions that they feel is appropriate in light of the information provided to the court. We would not want him released. And it could be very well that we want him to testify, because it was, in fact, David, and not Janet Arvizo, who was involved in this incident, and the son, the victim in this case, was not buying what the father was trying to get him to do. So that, in essence, is our position on this, Your Honor.
May I respond briefly?
Just a moment. Here's the question I have. I can't tell from the declaration of Mr. Sanger, or from the attached reports, if Gavin, when he called Mr. and Mrs. Lopez seeking the return of his wallet, claimed at that time that there was several $100s in the wallet. I can't tell if that's your proffered.
Here's the state of that situation is this, as I understand it. Louise Palanker says that she was advised of this wallet incident because it was a big topic of discussion.
But can you answer my question?
Yes. And when she was told about the incident, which is double hearsay, or hearsay at the very least, when she was told that Gavin made the call, and that later, when David Arvizo tried to get him to stand there in the office and say there was $300, he said, well, I can't remember how much was in there.
Right.
Okay. Jamie Masada could not remember the incident until he was prompted, and then he remembered it. Then he couldn't remember all of it. So he went through several stages, but through the course of his statement, he eventually says, well, I don't really remember, as I recall, he says, I don't really remember what Gavin did. So we don't have a clear understanding, or a witness who is going to clearly say they heard what he said. Hence,
to the Lopezes when he called them.
That's right. Other than Mr. Lopez, Mr. and Mrs. Lopez.
So the statement under your declaration on line 21, 20 and 21, are you there?
Yes.
Gavin later called Mr. and Mrs. Lopez seeking return of his wallet. He claimed that it contained several $100s.
That's my understanding of Louise Palanker's claim. That's why we detailed it to show the court. I mean.
So we don't know that.
We don't know that for sure, but we've got enough. And as I say, there's a distinction here. And I think I answered the court's question. Okay, there's a distinction here between what Mr. Sneddon is proposing and what we're talking about at the moment, I think. Mr. Blancard, who's representing Mr. Lopez, did say he would file a supplemental declaration addressing the wallet issue.
Well, here's what I recall. And since I'm in the best position to.
Yes, evidently.
What I recall is that I overruled the objection to the subpoena and said that Mr. Lopez had to attend. And we agreed we wouldn't call him until April because of his business schedule. The attorney for Mr. Lopez then indicated he was going to file a motion to quash the subpoena, which is different than the objection that he filed. And I told him that if he was going to file a motion to quash the subpoena, I would require a detailed statement from Mr. Lopez as to this wallet incident so I would know what he did or did not have to offer the jury in the way of evidence on the issue. He has not filed a motion to quash the subpoena, so the subpoena is still in effect. And he's under no duty to file any declaration absent. Only if he files a motion to quash, and that would be in an accompanying declaration.
That's absolutely correct, from my point of view, proving that the court is a very percipient witness on a.
Okay.
Now, I was just shortcutting that, because I didn't want to go through a long explanation, but the court very concisely did say what happened. The point of the story is precisely what I was getting at. Whether or not Mr. Lopez is called as a witness is not Mr. Sneddon's issue right now or my issue right now. The issue right now is whether or not we can confront and cross-examine the witnesses with this incident.
I agree.
And I think
you can.
Okay, thank you.
The difference we have is, and there's been maybe some misunderstanding from the district attorney, judging from their objections, that on the 403 hearings, when I said that certain things couldn't be proved, I also said that that did not bar cross-examination of certain witnesses on those items, and that's what was going on some of the ones earlier this week where you seemed to be surprised that I was overruling your objection to cross-examination on some of those issues. So I agree with you, that cross-examination of witnesses that have knowledge of this would not be inappropriate. There's limits on that, of course.
Well, I understand. The court makes rulings as you go along, obviously. Okay, thank you. I believe that resolves that issue. We did have one more matter that we had. It's not on the agenda.
Yes, we'll take that up now. A motion for a mistrial.
That's right. And
Let me rule on the first motion first, because it's connected, in a way.
Okay.
And you connected it. What I'm going to rule on the motion for admission of evidence on the alleged prior sexual offenses under Evidence Code Section 1108 is that we will hear argument on Monday. What date would that be? Would that be the 28th?
Yes.
On Monday the 28th. The way I think I would like to do this is not to call witnesses unless I get to the point where I want to have a witness. So I'll have the prosecution make their arguments as to why they believe particular witnesses should be called as to particular items, what they're going to say. And I'll allow the defense to say, they can do this in advance. I would encourage some written material if you have time to do it, but not requiring it, as to why, in a particular case, what you would be doing and why you think it should be excluded under 352, and let you argue those things. And then I may or may not ask for a witness in any particular situation. It will depend on how I hear what you have to say, what my opinion is then.
And if you were going to request a witness, would it be on a different day, or should we have people lined up outside the courtroom?
Well, let's make it a different day so that we don't have to inconvenience all sorts of people.
Okay.
But I'm pretty much of the opinion now, having read the cases on this, that the likelihood of having any witnesses is not great.
It's not what? Not great.
Now, on your motion for a mistrial.
Yes, sir. First of all, a motion for mistrial is generally made orally. And it was made orally in this case, just so the record's clear, by Mr. Mesereau when he said, I have a motion.
He did. I understood what he was saying. And I asked him to wait, and he did. And the record was made timely, if that was an issue at all.
I just wanted to. We have to connect the dots on the record, so I just wanted to make sure we did that.
Yeah, that is your right.
Thank you. And I understand that we're not supposed to say the word mistrial in front of the jury, and therefore we don't.
That's correct.
We filed a memorandum of points and authorities in support of the motion for mistrial this morning. Hand-delivered it to the district attorney. A mistrial, though, is generally, a motion for mistrial is generally made orally, and I intend to make this orally. The points and authorities just support what we said, and I'd incorporate the points and authorities in my oral presentation so that I don't have to repeat everything. Having said that, the basis for the motion for mistrial is that the court made a ruling, whether the court intends, or, I shouldn't say, intends, whether history bears out later that the court either grants or denies the 1108 motion. The prosecution was under a clear duty not to go into 93, 94 matters. And what they did, what Mr. Auchincloss did specifically, was not only ask a question that, to which a witness responded out of the blue, and named names. And I'll just avoid saying the names right now, but it's already in the record, and everybody will see it, I'm sure. But, that can happen. You tell your witness there are certain rules, and the witness gets up on the stand and they're nervous, and all of a sudden you ask a question, and they blurt out things that they're not supposed to say. That's not what happened here. What happened here was that the witness came up with one name, which was Macaulay Culkin, and Mr. Auchincloss, not being satisfied with that, went back directly to the very list of names that he has in his 1108 motion, that he's been asking the court to be allowed to go into, and the court said, no, not until we rule on it. And he asked leading questions. What about so and so? And then they said, yes. What about the next person? She said, yes. It's in the record and I've cited it. I just don't want to repeat it unless the court wants me to.
No. Based on your written material, I read that record this morning.
And when you compare that to the 1108 motion, there's nothing accidental about this. Now, the issue or the problem that I see here is that, number one, the court's order has been blatantly disregarded. I'm not saying that from the standpoint of being punitive. I'm just saying, as a practical matter, that's exactly what happened. It couldn't have been any more blatant and it couldn't have been any more intentional. It was clearly done with leading questions. So as I said, there's nothing accidental about this. And it goes right down the list of the people that the prosecution wants to talk about. If you compare the 1108 motion to the transcript, it's exactly what he's doing. He's getting in the information that the court had said don't get into until we have a chance to do it. So I think that the only remedy at this point is a mistrial. Now, the prosecution could argue, well, you should grant our 1108 motion anyway, so there will be no harm, no foul, which means they can then put the court in this difficult position, deliberately violate the court's order, and then get the benefit of all worlds on this. That can't be right. There's got to be a sanction. And the only appropriate sanction, reluctantly, I say this reluctantly, is a motion for a mistrial. And I say it reluctantly because I think that when you look at the cases such as Oregon versus Kennedy, the United States Supreme Court case that we cited, and the People versus Batts, which is a California case, the case law says that if a mistrial is granted based on prosecutorial misconduct, and it's granted not at the request of the defense, then jeopardy may have attached and the case is over. On the other hand, we're in that position where we have that choice. Do we stand here and just say, well, we're going to take it, because if we request a mistrial and the court grants it, they can just start all over again and prosecute again? After considering this, we've decided that the only thing we can do, as a practical matter, is ask for a mistrial as the first remedy. If that's denied, there may be other remedies. But I think we have to, in good conscience, given what happened, and the blatant nature of the violation, I think we have to request a mistrial. Now, the prosecution can come back and say, oh, well, what's a little violation of the court order here? I mean, we've spent a lot of time and money. The court's spent a lot of time and money. Look at all these sheriffs are here helping us get to our cars and do things, and the press. That can't be a reason to overlook something that in any other case would be just an absolutely intolerable violation of a court order. He went down with leading questions, went down the list of people that the court has already indicated you can't get into until we have a hearing on it. So what do we do? As my former colleague in this case used to say, we have to do something more than nothing. And I think that that's precisely what we have to do in this case. And I think the only proper remedy is to grant a mistrial. None of us, believe me, wants to sit here and start this case over again. But what? You can't unring the bell. They've gotten into specific names and specific allegations that they were told not to get into, and here we are. Now, if the court decides for some reason that a mistrial should not be granted, then we've suggested another possible sanction. But only if the court denies that motion for a mistrial. We've also indicated that we believe, and I'm saying it up front and I've said it in the papers, that this, even though we have requested a mistrial, this still may come within the exception under the Kennedy v. Oregon or the People v. Batts cases, in that this appears to be such deliberate misconduct, where the very names are read in leading questions that are in the motion, that it would be viewed as a case in which jeopardy is attached and mistrial is deliberately caused, and there may not be a retrial. But whether that's the case or not, those consequences are not for the court to weigh at this point. The court has to weigh whether or not there was just a blatant disregard of the court's order, and if, based on that violation, a mistrial should be granted. And we respectfully submit that that is the proper remedy. And then, as I say, if the court disagrees and doesn't grant a mistrial, then we've suggested, among other things, as a sanction, the 1108 motion should just be summarily denied, the people's motion on that, because that would at least be a sanction to deal with this. The court could then issue an admonition that the reference to people prior to the 2003 time period will be stricken. You're not to regard them, and we could go from there. Thank you, Your Honor.
Counsel.
My first comment is that Mr. Sanger points out one of the anomalies of the law that we face when we try criminal cases, and that is when there's an allegation that someone on the prosecution side steps over the boundary. All of a sudden the defense can get up and make mistrials and characterize it in a certain fashion. But on the other hand, when we sit here and watch defense counsel continuously step over the boundaries and get admonished as violating the court's 403 rules, the prosecution's basically at the mercy of the court, because the law does not allow us to make any kind of motion to rein in or bring under control somebody who just consistently violates the court's orders. Having said that, two wrongs never make a right, so I'd like to address the correctness of why we believe that this motion should be denied. There should be no sanctions, and why the court should ignore this, in the sense that it was not deliberate and not intentional. First of all, the court's 1108 motion dealt with specific allegations of misconduct on the part of the defendant involving other young boys. There was no attempt to elicit that information from these witnesses. There was no intent to infer that there was any improper conduct on the part of Mr. Jackson with the individuals. The questions were directed totally at the witness with regard to who were people who came to the ranch and visited Mr. Jackson on certain occasions. And frankly, given the court's ruling on staying away from the 1108 areas of misconduct, I can't see how, frankly, it comes within the purview of just simply asking whether these were individuals who came to the ranch during a particular point in time involving the period of time in which this person was an employee at the ranch. In fact, the court sustained some objections, but most of the objections you sustained were on the basis of foundation. And it was at that point when Mr. Auchincloss went back and went through them serially, individually. You did not overrule, in fact, you overruled objections on the part of the defense as to some of those questions. Now, I think it's pretty hard to stretch that kind of questions and those kind of answers in the kind of context that they were presented as being prosecutorial, deliberate misconduct on the part of somebody, when it was clear that there was nothing inferred with regard to the conduct of these people at the time, and the conduct of the defendant in relationship to these people. And so I just submit to the court that, given the whole series of questions and answers and the sustaining of objections, that there was nothing really improper that happened in the first place, that this is part of the give and take at trial. And some of the boundaries, I think the court would probably, you won't take judicial notice of it, but the court has tried to guide us generally through some of these landmines in this case, and it's not altogether sometimes clear just how far one can go and one can't go. And I think that's been a problem on both sides of this case. But to say that something is deliberate and something rises to the magnitude of some kind of a mistrial declaration in this particular case, I think is a very, very big stretch in light of what happened in the total context of this trial and in the total context of the examination of this witness, Your Honor.
Any rebuttal?
Yes. First of all, I'd feel a lot more comfortable, rather than bringing up other things and then saying two rights don't make a wrong, if we just address the issue. And also, I'd feel a lot more comfortable if the prosecution indicated that they were wrong. However, what's happened here is we're saying there was no intent to infer. And as we cited in our papers on page 2, and including the footnote on page 2, that it was Mr. Auchincloss, not Miss Fournier, who said things like, special relationship, and special friends. It was Mr. Auchincloss who was trying to make this relevant to his 1108 motion. It was Mr. Auchincloss who brought out the ages of the children. It was Mr. Auchincloss who asked questions only about boys and not about girls. He chose to do that. Why? Not because it was a random discussion of Miss Fournier and what she'd been doing on the ranch for 10 or 12 years. This is directed specifically to the inference. And Mr. Sneddon just got up and said there was no intention of bringing out. You know, I'm just taken aback by that. Of course there was an intention to infer something by this testimony. I can't believe we're in the same courtroom. And if you look at that, when Mr. Auchincloss goes on about special relationships, special friend, ages, boys, he's clearly tying it into his 1108 argument. And if he wasn't doing that, the relevance objections would have been sustained, I'm sure. It was offered as relevant evidence. It wasn't offered for some background of Miss Fournier. And the court ruled earlier that that evidence would not be admissible until the court had a hearing on it. So, you know, it clearly was improper, and it clearly was for a purpose. I just can't believe I heard to the contrary. The question is, you know, what does the court do about it? And in saying that somebody on the defense team overstepped boundaries from time to time makes this right, it just doesn't. And the defendant does have a constitutional right to a fair trial and to have the court's orders followed by the prosecution. This is a bell that cannot be unrung. And I just think under the circumstances, there's no choice but to grant a mistrial. As, you know, remarkable as that might seem to the public or somebody else, the fact is, as lawyers and as a judge, we all know that there are legal rules. These legal rules, in this case that the prosecution follow the court orders, were not followed, and the consequence of those breaches of legal rules is that the court has to declare a mistrial, and I believe that that's the appropriate remedy. Thank you, Your Honor.
Judge, I promise it will be less than a minute, but I wrote something down that I didn't tell you that I think is relevant to this issue.
No, we have.
All right.
We have opening, response and reply. Well, let me tell you how I was looking at it when I was making the rulings, which is there was some evidence by the district attorney from which he would like to prove or have the jury infer that when children go to Michael Jackson's ranch, that they are unsupervised. They become wild and crazy kids, you know. There was a lot of, the inference they wanted to be drawn, I think, was that is a situation that Mr. Jackson wanted. That he didn't supervise them. He wanted them to become uncontrolled children. Then Mr. Mesereau, in cross-examination, spent a good deal of time trying to establish. That's not a good word, trying. I should say working to establishing that, in fact, many truckloads, busloads, not truckloads, busloads of children, carloads of children, appeared at the ranch when he was there, and when Michael Jackson was there, and when Michael Jackson wasn't there. And there was an ongoing entertainment of children, and that the children acted as children do when they're taken to any amusement park. And that, in fact, Mr. Jackson wasn't there a lot, and wasn't out watching them a lot and really didn't have much contact at all with all of these children who took advantage of the rides and zoo and everything. And then the district attorney came back in my acceptance of that evidence at that time, was to try to re-establish or to establish the contact that Mr. Jackson did have with the children. And that, in fact, there were certain children that he had a great deal of contact with, and that this was the balancing of the evidence that I was watching from this position. And so when the district attorney asked if there weren't certain children that he had established good, strong relationships with, and she confirmed, the witness confirmed that that was a fact, and started naming them, I didn't feel that violated the 1108 order. I didn't see, from my standpoint, I didn't see that it was either harmful or helpful to either the defense or the prosecution. I mean, some of the children that were named were relatives of Mr. Jackson. And I did specifically limit that testimony to that area purposefully. And I thought the district attorney recognized it when he said he intended to go no further than that, and I said I would hold him to it. And then when he did mention Geordie Chandler, he said, he was the one that raised it, not the witness. How about Geordie Chandler? And she said, yes. And Mr. Mesereau said, Your Honor, I'm going to object based on the court's ruling on 1108. The court sustained, and Mr. Mesereau said, move to strike. and the court struck the testimony. And it was after that, of course, that Mr. Mesereau moved for a mistrial. But I felt that that cured the situation. And one has to keep in mind that this isn't the first that the juries heard that name. And even one of the questionnaires for service of jury was to ask the jurors what they knew about the alleged 1993, or the 1993 alleged incident. And it's come up, 1993 has been mentioned by other witnesses. So it's not like this is the first, nor will it probably be the last time it's mentioned. So I'll deny the motion for a mistrial and any request for sanctions. Let's see, is there anything else before me?
Judge, may I ask a question about the procedure on the 28th, in terms of what the expectations are, us moving forward with our case? And then I have one minor thing that I'd like to discuss.
Yes.
Before you change the subject, though, could I just ask one clarification question on that ruling?
Yes.
Just so we don't have a problem. I mean, the court is going to rule however it's going to rule.
The court ruled however it did rule.
That's true. I'm speaking about prospectively on other, if this comes up again. It would be our position that mentioning the names of children who are in the 1108 motion, whether they're there because, well, for whatever reason, mentioning those names from 93, 94, or prior to that should not occur. It would be our position, unless counsel approaches and asks for permission. Because I still believe that that comes within the 1108. I understand what Your Honor said. I'm not arguing with the ruling. But prospectively, until the court rules on the 1108, that would be my belief and understanding. And I'd ask if we could follow that procedure. That if there is an intention to do something like that, that we have an opportunity to be heard on it.
I think that's only fair. There could be other situations where that testimony is admissible before we get to 1108. It's not admissible under 1108 or, so it would have to be some limited purpose. But to prevent the need for further hearings like this, I think you should advise them if you're going to go through that list.
Okay.
Before then.
Thank you, Your Honor.
Judge, on the 28th, when you said we were going to have argument, should we anticipate that that will take the day, and we shouldn't be required to have witnesses standing by? I don't even mean in connection with the 1108. I mean just.
Yeah.
To carry on that day. Do you envision that would take the whole day or part of the morning? I just want to get direction so.
Well, how long do you think your argument will take?
Depends on whether it's, who's arguing it. And depends on how much leeway the court gives.
How much?
Based on our experience, I would expect it would probably take a couple of hours, I guess.
I think at least. What do you think? Who's arguing that here?
I believe I am, Your Honor. I would say it's liable to take a couple hours. We could intend to take an hour, but we'll probably take a couple by the time we're through.
So are we talking 2 hours? Are you each saying 2 hours total, or are you saying 2 hours?
I would.
Each.
No, I would anticipate that I would be able to address the court's concerns in my opening remarks. And since it's our motion, we carry the pail on this one, that probably I could do that in a half hour easily, because you already have our declarations.
I already have your written declarations.
So I'll just highlight things and we'll go from there. So I would expect that my opening would take less than a half hour.
And by the time I get through going back and forth, I think total, the whole thing will probably take a couple hours. And we'll probably have a break, so.
So if we had the jury come in on Monday at 11:30 and did the 11:30 to 2:30, that would work.
I think that would be fine. If the court needed more time, we could do the jury and take more time on another day.
So 11:30.
So we're going to argue. The arguments will start at 8:30.
Yes, sir.
But you'll need to have witnesses commencing at 11:30.
Is it the court's intention to rule that day?
Unless I need to call a witness.
Okay, so if the court rules in our favor on one or more witnesses, we could go ahead and put them on right away, then.
Yes.
All right. The second thing is kind of a personal thing, and it involves the court also. You indicated we would not be in session Tuesday afternoon, and the reason is the dedication at the Juvenile Hall. And I know they're dedicating it to Sue Joan Frido, who is a close personal friend of mine, and we've been colleagues for over 30 years together, and I was very close to her and her deceased husband. I had intended to attend that service, but then you invited all the jury, and I'm a little squealy about going over there, because I don't want to run into a juror, and I don't want to get accused of any improper conduct. So I guess what I'm asking the court is,
I would expect you to attend, and I don't expect any of the jurors to attend. Did you notice the laughter when I
know, Judge. But I just want to make sure that I've consulted with you about that.
I'll address that with them Monday and tell them I really don't expect them to attend. I think they're in tune with my humor.
I don't want to get accused of showing up if you said they were going to be there, or something like that.
No, I understand. I think everybody, Mr. Sanger might even want to be there.
I was going to say, Sue Joanfrido has been a good friend of mine for a long time, too, and I intend to attend. And I assume if we saw a juror, we would go in a different direction.
Yes, I'd require them to wear their badges if they went. I don't think they're going to go. They're really looking forward to the break.
Last thing. Do we have an update on the computer? We're in the middle of trial here. We'd like to get some of that information. Are we done with at least one of the computers with regard to the...
I'll have to defer to Jed.
The last word I heard was that the disk, based on the new list, was in the mail yesterday. And so as soon as the special master makes a ruling, that material will be available.
Can I ask a clarifying question? My understanding was that the Brad Miller computer was completed and that the scoping down of the inquiries was on the Evi Tavashi computers. Am I mistaken about that?
It's the other way around.
The other way around?
Yes.
Oh, but the Evi Tavashi is completed, but Brad Miller's is the one that we're re-evaluating.
Yes.
I'm sorry, Your Honor, I was trying to get to the point.
Go ahead and address him. He knows. Go ahead.
Have the Evi Tavashi materials been given to the special master?
Yes.
And then the next process is it goes to the judge. Judge Melville will make a ruling from there.
Yes.
I'm just trying to get an update, Judge.
I agree.
We're in the middle of trial and...
It's just something that didn't know any more than you did. So we both now know where it is.
Perfect. Thank you very much. Thank you for your indulgence.
All right. Is there anything else?
I don't think so, Your Honor. Thank you.
All right. Court's in recess. Have a good weekend.
Thank you, Your Honor. You too.
Have a good weekend, Your Honor.